I'm excited for us to continue our journey with our Launchpad series and intellectual property Launchpad series. So I'm excited about this. My name is Savola Frazier. I am one of the board members for BILF, Black Innovation Leaders of Florida. And we're excited to be partnering with the U.S. Patent and Trademark Office to really provide this information to our community. This has been an exciting time. There's been a lot of key information that has been shared across the board. And this is really an opportunity for us to continue to enrich our community with these nuggets to help us to understand the key basics of what we need to understand when it comes down to patents, many of us have those inventions, and how do we actually take those steps when it comes down to trademark, and how do we utilize that. And even in the last session that I was in, it wasn't the previous one, but the one before that, Gotham did a really great job of sharing with us those resources that are out there and helping us to truly understand where we can go to get access to a lot of free resources to help guide us on this journey. So there's been a lot of key nuggets that have been shared with us during our time over the last 3 weeks. And today, I think, is no exception. We have a wonderful host with us today, Christina, and joining along with Gotham to continue our journey today. And we're going to continue the journey today talking about trademarks. And today is all about the basics of trademarks. So if you've had questions on how to go about doing this, where should you start? You are in the right place today for our discussion. And if you know of other participants that are dragging behind a little bit, please go ahead and ping them and say, hey, we're getting started. It's time for you to hop into the room and continue this conversation. All right, without further ado, I'm excited to have Christina join us. Thank you so much, Christina, for being here with us today. This is an exciting time. We know that there's so much information about trademarks, and there's so many different questions that people have about it. And it's such an honor to have you in the space today to really just share this out. So if you want to kick us off by sharing just a little bit about yourself, and then we can hop into the content for today.
Great. Thank you so much. Thank you so much for having me. Again, my name is Christina Calloway. I'm an attorney advisor in our trademark customer outreach office with the USPTO. I know you probably already know, Gotham probably talked about, is that the USPTO is the federal agency that's responsible for granting patents and registering trademarks. So today we're talking all about trademarks. I have been with the agency for about 8 years. I was a former trademark examining attorney. So I was one of the attorneys that reviews the applications that come in. So I know all about that. And I also worked on a special team that was specific to sound and motion marks. Not many people have experience with sound and motion marks. So I got the chance and had a pleasure working on those particular marks. I'm not located in Florida, but just a little tidbit. I'm a military and proud Army brat, but my mother is from Miami, Florida. I recently came from a vacation in 38 right outside of Panama City, and most of my family on my fraternal side is from Florida, St. Petersburg, Fort Lauderdale. So I know all about Florida, love spending time down in Florida. So kind of feel like I'm there with you by doing this presentation today. So we'll go ahead and get started. Just give me a moment to share my screen.
And we'll definitely send you some of this Florida sunshine.
Yes, I love it. Literally just had a vacation there. All right, everybody should be seeing trademark basics, what everyone small business should know now and not later. We're going to get right into it. I'm going to kind of discuss our agenda for this afternoon. The way we're going to play it is I'll discuss specific topics. After I finish, I'll take probably a moment, like 1 or 2 minutes, to go over any questions you may have about that particular subject matter, and then we'll move on. If you don't have any questions, if you want to wait until the end, please feel free to drop your questions in the chat so you don't forget them, but we'll also have time at the end of today's presentation to answer any questions that you may have. So without further ado, let's go ahead and get started. So first, we're going to be talking about some basics, the trademark fundamentals, some definitions. We'll be going into what are the benefits of federal registration with the USPTO. We're going to talk about how to select a trademark, or if you already have a trademark, what you want to be thinking about to make it stronger, to have that strong brand distinction and brand identity. Then we're going to talk about simply talk about the process, or the filing and registration process that you're going to go through, as well as provide you with some resources, free resources and materials that the USPTO provides in order to help you get started with that federal registration. So let's talk about our trademark fundamentals. So I know we have people at probably different stages of their entrepreneurship journey, or different levels of understanding about trademarks. So we're going to start at the very basics. Trademarks are a type of intellectual property. Intellectual property is something that you're creating with your mind, and you can receive protection from it from a federal agency. Now, it's not something, of course, it's not tangible, it's intangible type of property, but it can still be bought, sold, traded, inherited, licensed. So it's something you possibly want to think about having protection for, so that you can do that or have that legal protection for your brands. So a trademark is something that you are using to indicate the source of your goods and/or services. So it could be anything, could be words, it could be phrases, it could be numbers, letters, acronyms, design elements, colors, different types of font stylizations, whatever you're using to indicate the source of your goods and/or services. So I'm showing here on the screen now some very well-known types of trademarks. And as we go through them and as you're looking at them, I want you to think about what you think about when you are associating with these particular brands, or these particular logos, these brand names. What types of goods and services do you think about? So when you see that have been Apple, what are you thinking about? Probably like a smartphone, right? Or computers, or those music streaming services. When I see those arches, that M arch, even without that color that I may recognize, you might be thinking of fries. I know it's lunchtime, hamburgers, or you may be thinking about those restaurant services that McDonald's has. When you see that swoosh, that's called a swoosh, that Nike swoosh, you're probably thinking about footwear. When you see Amazon, the word Amazon with that smiley face arrow, you're probably thinking about those online retail store services. So with these particular marks, these trademarks, they're always associated with some type of good and/or services. Same with your trademarks. It indicates the source of goods and/or services. So we know that's the definition, identifying the source of goods and services, but trademarks also distinguishes one party's good from goods and services from those of a third party. So think about that for a little bit. I always like to use the example of Coca-Cola and Pepsi, right? So I'm a Southern girl. I love Coca-Cola. Coca-Cola is headquartered in Atlanta, Georgia. I love Coca-Cola. Pepsi, their rival or their competitor, also provides the same type of goods, right? They provide carbonated type soft drinks. But when I go into the store, if I go to a restaurant and ask for something to drink or ask for a Coke, I don't want them to bring me a Pepsi. I want that Coca-Cola branded product. Even though they're providing the same types of goods, those two different trademarks help them distinguish and create that brand distinction, right? For their consumers to have brand loyalism to those particular marks, which results in some type of economic value attached to those trademarks, right? That strong brand identity, that brand distinction, even though they're providing the same types of goods. Also, a trademark can also provide you with legal protection for your brand. And we'll be talking about how you can receive some of those protections through federal registration with the USPTO. So now we know what a trademark does do, right? It's identifying the source of goods and services, helping us distinguish our brands from those of another party, as well as providing that legal protection. Let's talk a little bit about what it does not do. So a trademark does not mean that you legally own a word or phrase. So you may have a word or phrase that you're using in your trademark, words, terms, phrases that you're using in your trademark. It doesn't mean that you own those particular words or phrases. Let's use Apple, for example. Apple is a general common word, right? It identifies a type of fruit. We have to be able to say the word apple. So Apple, the company, does not own the word apple. A trademark, or that protection registration, allows them to have exclusive right to use that wording in connection with the goods and their services that they're providing, that they've come in for those registrations. So they don't just own the word outright. It also does not mean that you can stop other people from using the word. So Apple can't stop us from saying the word Apple. But if I were to create a smartphone and try to name it Apple or something of that nature, then they're going to have a problem with it, right? Because they have the exclusive right to use that word in connection with those types of goods, right? They want to make sure there's no confusion in the marketplace. Someone isn't infringing upon their trademark. And it also doesn't mean that people owe you money every time they say a word or a phrase or terms that is in your trademark. Okay, so doesn't mean you legally own that wording, doesn't mean you can charge someone for saying it, or that you can stop other people from saying it. But in connection with your goods and or services, yes, there may be an issue if there's some confusion, someone is infringing upon your mark, then you have the exclusive right to use it in connection with those goods and services. So that there is where an issue may lie. So trademarks, I'm using the word trademark interchangeably for goods and or services, but trademark usually indicates the source of goods and or products, and then service mark indicates the source of services. I use the word and it's used in the marketplace interchangeably for goods and or services. You'll probably hear me say trademark more than service mark, but if I happen to mention service mark, it just means it indicates the source of services. Trademark indicates the source of goods and or products. So when we're saying trademarks, you probably don't go out into the marketplace, or when you're selling and providing goods and services, you're probably not saying, I have a trademark. You're probably using a more common source identifier, like saying, this is the brand name for my business. I have a slogan for my business. This is the logo that I'm using for my brand or business. You're probably not using the term trademark. And those are common source identifiers that you're going to hear in the marketplace. And these are what are called trademarks that indicate the source of goods and services. So Coca-Cola, for example, Coca-Cola, we don't normally see in this typeface, Times New Roman typeface font, right? We normally see it with some type of stylization, some colors here, but Coca-Cola has registrations for just the wording, Coca-Cola, just their slogan, it's the real thing. And then they also have registrations for what we commonly see, right? The stylization of that font, the color, those red and white colors, their design elements, the way they may be stylizing those particular logos that they're using. They also have a federal registration for the shape of their goods or the packaging for their goods in that iconic Coca-Cola bottle shape. It's called a configuration mark. So they have had enough brand distinction in just the shape of their packaging that it can indicate the source of those goods and services. If you see that glass bottle, even without seeing the label, you probably know it is a Coca-Cola branded product. This is a type of non-traditional type of mark, and we'll discuss those in just a second. So a trademark is anything that you're using to indicate the source of your goods and services. Anything that may be functioning as a source indicator might be eligible for registration. So we just talked about that Coca-Cola bottle shape, right? That's a kind of non-traditional type of mark configuration, the way that the goods are packaging or something, a color or something on the packaging that may indicate the source of those goods and services. So I talked about that I worked on a team that was responsible for reviewing those sound and motion marks. So let's talk about sound marks. Think about the NBC chimes. If you turn on NBC or before one of their shows, they're going to have that stylized peacock symbol, and then it's going to give off 3 chimes for NBC. That's for their television broadcasting services. I am a huge Law and Order SVU fan. It's one of my favorite television shows. And even before that show, after they do their lead in, I'm going to hear a dun dun, which means the show is about to start. That's a sound mark for that television series, those television services provided by NBC. Okay, so that's what we're thinking about when we're thinking about sound mark that is distinctive for whatever goods and or services. Color, for example, if I were to hand you a package that is in robin's egg blue, you're probably going to get very excited because you know that something's nice is in that package without even seeing the label of Tiffany's across the top of that packaging. That robin's egg blue on the outside of that packaging is a trademark for those goods or those jewelry goods. Think about the color brown on the outside of that UPS truck, right, for those parcel delivery services, or even on their uniforms for those parcel delivery services. The underbottom of a Christian Louboutin shoe, that red sole, indicates the source of those particular types of footwear. So that red sole is a type of color mark for those goods. Scent and smell. Play-Doh has a federal registration for the scent of those goods. So even as an adult, I'm sure you can remember that smell, or if you have children and they're playing with Play-Doh, you know that distinctive vanilla musky scent. That is a federally registered trademark for Play-Doh and Mattel company. Motion marks, think about at the beginning of a film production, that roaring lion for Metro Goldwyn Mayers. That roaring lion is a motion mark for those particular film production services. Holograms that could be on trading card, baseball trading cards, on an American Express card, that can be a trademark for those particular goods indoor services. And we talked about that configuration or shape of the Coca-Cola bottle. So these are those non-traditional types of marks. Anything that can function as a source indicator might be eligible for registration. Now, before we move on and get into any questions specifically about just what trademarks are, the types of trademarks, what they do and don't do for you, let's do some quick knowledge checks. And I'd love to have your engagement either in the chat. You can just drop yeses or nos in the chat so I can see them. I'm going to open that here. And does a federally registered trademark mean that you own a word or phrase? When you get that federally registered trademark, does that mean that you own the word or phrase that is in your trademark? Thank you. I'm seeing those answers come in. Thank you so much for your participation. The answer here is no, right? It only means that you have exclusive right to use those terms or phrases in connection with your goods indoor services. Remember, we talked about that Apple example. Apple is a general word. We need to be able to say the word Apple. But in connection with smartphones, Apple has the exclusive right to use that particular term. Let's do one more. Do you have to use your business name as your trademark? Think about that one. Do you have to use your business name as your trademark? And I'm seeing answers come in. Yes, I'm seeing a lot of no's. That's great. Yeah, you can use your business name as your trademark, but you're not required to. You don't have to. So the answer here is no. You can use whatever you're using to indicate the source of your goods and services. So you could have your business name for your business, of the goods you're providing or the services you're providing, but you have a different trademark for those goods, the products, or those particular services. Or you could use your business name as your trademark as well. That is a decision that you're making as an entrepreneur, as an intellectual property owner. Okay, before we move on to the benefits of registration, do we have any questions specifically about trademarks, what they are, the types of trademarks, and types of trademarks, non-traditional types of trademarks? Any questions that you have before we move on to the benefits of federal registration? I'm just going to check the chat to make sure I don't miss anything. Okay, looks like everybody's gotten the basics. So again, if you have a question and it comes to you and you want to wait, please feel free to drop it in the chat. We can always get to it at the end of today's presentation as well. Okay, so the benefits of federal registration. We talked about what trademarks are, what they can do for you. Let's talk about how to protect your intellectual property. So trademark rights in the United States are based upon usage. You're using your mark in commerce for the goods and or services, in the marketplace. And there are two types of ways of creating those rights. That's common law rights as well as federal registration with the USPTO. Let's talk about common law trademark rights. So first, trademark registration with the USPTO is not required. This is for federal registration and the benefits you receive from federal registration. And we'll talk about those benefits in just a moment. But in general, trademark registration with the USPTO is voluntary. This is a choice that you're making as an entrepreneur based upon the benefits that you may want to receive connected with that trademark. So as soon as you create a trademark and you're using it in commerce with your goods and or services, you have common law trademark rights. However, these particular rights are limited to the geographic area where your mark is used. So think about, for example, if you are selling candles at your local farmer's market every Saturday, and you're providing those candles, you have a trademark that you have on the label on the front of those candles and you're selling them at that local farmer's market, then you have a trademark. You don't come to the USPTO to buy or purchase your trademark. You're coming to register your trademark because you already have a mark that you're using in commerce in connection with your goods and or services. However, under common law rights, that is just going to provide you protection for the geographic area where that mark is used. So if you're providing it at locals farmers market in Florida every Saturday, you're only going to have protection in the state of Florida. So since you have that trademark, you can use TM for your goods or products or SM for your services, for service mark, TM for trademark, but you would not be using the R with a circle because that indicates federal registration with the USPTO. So you can put a TM or SM prior to federal registration. But think about if you're selling those goods at the farmer's market and someone from out of state comes to the farmer's market, they're visiting the area, they purchase those goods, they love your trademark. They think it is just wonderful, so innovative, so distinctive. And they go back to their state, say the state of California, and they say, well, I'm going to just buy some candles and I'm going to slap on this trademark. I think this is such a cool trademark. Well, under those common law rights, you would have would not be having any right with them in California because you would not have any rights in California. You just have rights in the state of Florida. So what if you want to broaden those rights? You want to make sure that no one in another state is selling or using your particular mark in connection with the same or related types of goods and/or services. That is where federal registration rights come in. So once you have that trademark, you know you're going to be using it in commerce with particular goods and/or services, you can federally register your trademark with the USPTO. This is going to provide a legal presumption that you own this particular trademark in connection with these goods or services, and it's going to broaden your rights to all 50 states as well as the US territories. So if someone were to take that candle and use that mark in California and you're based in Florida, then you would have the legal right to send them a cease and desist letter and say, you cannot use this trademark in connection with these goods, same or related goods and/or services. Or if they were not to stop, you would be able to sue them in federal court under a trademark infringement lawsuit. That federal registration is also going to put the public on notice of your rights. So once you have those rights or that federal registration, like I talked about, you can bring that legal action concerning your trademark in federal court, and you have to have a federal registration in order to do so. You are able to record your federal registration with US Customs and Border Protection. So think about goods that are commonly copied or knocked off, right? Maybe electronic goods, software, those clothing apparel goods, handbags, right? So you don't want someone importing or exporting your goods that may be goods that are of lower quality using your trademark out to others. So you are able to file your federal registration with US Customs and Border Protection, and they can kind of prevent that from happening, from occurring. You're also able to use your federal registration as a filing basis in another country. So think about if you are providing goods in the United States or selling those goods in the United States, but you're manufacturing your goods in another country. You may want to think about getting protection, that trademark protection in another country. So although there are no worldwide international protection rights, you have to go to every country's intellectual property office in order to get that protection. If you are manufacturing goods in another country, you can use your US registration as a filing basis in that other country, okay? So no worldwide rights, no international rights. Once you receive your federal registration, you get the rights in the US, but you can use it as a basis for filing in another country. Now, once you get your federal registration, you are able to use TM and SM, but you're not required to. It's not necessary that you do so. And now you're permitted to use that coveted R with a circle around it. You're not required to, because you will see trademarks out in the marketplace that do not have the R with a circle that are federally registered, but you are permitted to. And that is definitely going to put the public on notice that this is a federally registered trademark. Okay, let's do some quick knowledge checks about those benefits of federal registration. Are you required to register your trademark with the USPTO? Are you required to register your trademark with our agency? And you can just drop your answers in the chat. I'm looking at them come in. I'm seeing a lot of no's, right? No, the answer here is no. Federal registration is a choice. It is voluntary. So you're making that determination as an entrepreneur of if you want those benefits or if there's a reason that you do not want to, you make that choice. You may want to, or we recommend that you do so because one, you get those broader rights across all 50 states in the US territories. Thank you for your participation. And our last one here, does registering your trademark with the USPTO give you international protection? When you register with the USPTO, are you going to receive international trademark rights? I'm looking at those answers coming in. Right. I'm seeing a lot of no's. Thank you. So the answer here is no. So when you receive that federal registration with the USPTO, it's just going to give you rights in the United States and in our US territories. However, if you wanted to obtain rights in another country, you could use your US registration as a filing basis to do so. Okay, and I'll stop quickly right here for a couple of minutes or to see if we have any questions regarding federal benefits, the benefits of federal registration. And again, if you don't have any questions now, we can wait to the end as well. I'm just going to check over at the chat, make sure I don't have any questions coming in about those benefits. And I don't see any, so we'll move on to selecting a trademark or what you want to think about with your trademark if you already have one, or if you're creating a business, products or services, providing services, what you want to think about when you're selecting your trademark. All right, so remember, the mission of the USPTO is to register any trademark that is eligible for registration. Our mission is not to refuse registrations or refuse applications for registration. Our mission is to register any trademark that is eligible for registration. Keeping in mind that not every trademark is going to be eligible for registration, and not every trademark is going to be legally enforceable. And we'll be talking about the analyses that you want to think about with these. When you're selecting a trademark, you want to make sure that your trademark is both federally registrable, you want it to be registered by the USPTO, as well as legally protectable under trademark laws. Two main concepts to think about here. Likelihood of confusion, which is the most common type of refusals that applicants receive when they're filing an application, a trademark application with the USPTO. We'll talk about that analysis, but likelihood of confusion is that there's a likelihood that your mark is going to be confusing with another mark for the same similar types of goods and or services. And then another type of concept is the strength of the trademark or descriptiveness refusal. Another type of common refusal is that your mark is not distinctive, that it is merely describing the goods and or services. It does not indicate the source of those goods and services. Remember, a trademark has to indicate the source of those goods and services. So let's talk about that most common refusal first, the likelihood of confusion. So the concept here is that you want to avoid confusing consumers about the source of goods and or services, right? You want brand distinction. Our trademarks are supposed to be providing distinction or distinguishing between another third party's marks for goods and or the same or similar goods and or services. So you want brand distinction. You do not want to be causing confusion for consumers. So the test here is something that you want to think about when you're doing your homework prior to filing an application, a trademark application, is whether trademarks that you find in our database are confusingly similar. Do they look alike? Do they sound alike? Do they have the same meaning and connotation? Do they have a similar commercial impression? And you're also going to be looking at whether the goods and their services are related, not just identical, but whether they are related as well. So think about that. We're looking at in the database, before you're filing your application, you want to do a search in our database to say, hey, I'm coming in with this trademark. I want to see if there are any federally registered trademarks that may be confusingly similar to mine. Does it look alike? Does it sound alike? Same commercial impression, meaning and connotation. And then I'm looking at whether the goods and services are related. So if I have goods that are t-shirts, and then I see a confusingly similar mark for handbags, are those goods related? Are consumers used to seeing a company have both handbags and t-shirts sold under the same marks? Probably yes. So there could be a likelihood of confusion there. So it doesn't just have to be identical goods and or services. Now, if you're not meeting both prongs of this test, that's a good thing. You're not going to receive a refusal. The examining attorney is going to review under this analysis And if you meet both prongs in the test, you're going to receive an office action. Now you're saying, you might be thinking, hey, what if I don't? What if I have similar goods and or services or different goods and or services, but the marks are similar? Am I going to receive that refusal? And more than likely you wouldn't. Think about Delta for faucets and Delta for air transportation services. Identical marks, right, may have the same, they're pronounced the same, they look the same, may have the same meaning and connotation, but in connection with those goods and or services, consumers aren't used to going to buy faucets and also receiving air transportation services. So those trademarks are able to coexist on the register. Think about Dove for soap and then Dove for chocolate. Identical marks, but the goods and services may not be related. So they're able to coexist, right? Something edible as opposed to something that is inedible. So now that we have this analysis, the same analysis that I would do when I was a trademark examining attorney reviewing applications, let's think about some examples and how to work the analysis when you're doing your homework prior to filing your application. And the reason why I'm saying prior to is because when you file that application with the USPTO, you pay a fee, and that fee is for examination, or you be paying fee or fees in connection with that application, and that's to pay for examination. So if your application does not move forward to registration, you do not receive that money back. There's no refunds because that's for the examination process. So you want to be doing a little homework prior to applying so that you're not losing that money, or maybe thinking about or reconfiguring what your trademark is. Let's go through some examples using that analysis. So your trademark is T-Marky for shirts. And then the registered trademark that we find in the database prior to applying is T-Marky for pants. So would you allow this particular trademark to move forward to registration based upon that federal registration that we find in the database? You can drop either yes or no's, or if you can put I would refuse it, whatever you want in the chat to let me know what your analysis is. And let's go through those prongs. So again, our prongs are the marks confusingly similar? And then are the goods and services are related, right? So T-Marky and T-Marky, are those marks confusingly similar? Here, they're identical, right? Right, they're identical marks. They look alike, sound alike, may have the same meaning and connotation, commercial impression. They're identical. And then let's look at shirts and pants. Shirts and pants, okay, identical marks. Are consumers used to seeing these particular types of goods being sold by an entity under the same mark, shirts and pants? So more than likely, yes, right? And as a consumer, I can probably name 5 off the top of my head: Old Navy, Gap, Banana Republic, Ralph Lauren, Tommy Hilfiger. They all provide shirts and they all provide pants under the same types of marks. So in this particular case, this would result in a refusal. The marks look and sound the same, confusingly similar, and the goods are related because consumers are used to seeing these types of goods sold under the same mark. Let's change our registration a little bit. So again, that trademark you're coming in for is T-Marky for shirts, and then our registered trademark is T-Marky for pants. Let's go through that analysis. You can drop your analysis in the chat. So first, we're going to be looking at whether the marks are confusingly similar. Are these marks confusingly similar? T-Marky and T-Marky. We want to see if they look alike, if they sound alike, same meaning and connotation and commercial impression. So here I pronounce them in the same way, right? There's no correct way to pronounce a trademark because you don't know how a consumer may pronounce them. So T-Marky and T-Marky, I pronounce them in the same identical manner. So they are confusingly similar. Think about a radio ad or promo, how that would sound if you didn't see them in person. So here they sound alike. And then we know from our last example that shirts and pants, consumers are used to seeing those particular types of goods sold under the same mark. So this would result in a refusal for likelihood of confusion. Let's do one more example with our analysis and change the goods a little bit. So again, our trademark is T-Marky for shirts. And then the registered trademark is T-Marky for golf flags, T-Marky for golf flags. So let's think about that. We know from our last example, the analysis as far as are the marks confusingly similar, right? They do sound alike, even though they don't look alike. But shirts and golf flags, are these goods that consumers would be used to seeing under the same mark? Now, I'm not a golfer, so I don't know for sure if I walk into, say, Callaway Golf, for example, if I'm going to see Callaway Golf on shirts and Callaway Golf also on golf flags. Okay, so probably here, probably not refused. I'm seeing people saying, yeah, I'd allow it to pass through. The marks are the same, but consumers may not be confused by shirts and golf flags. Now, since I don't golf or don't have an understanding about that particular marketplace, as the trademark examining attorney, I'm going to want to do some marketplace research to make sure that consumers are not used to seeing shirts and golf flags sold under the same mark. It's the same type of research that you would do as well prior to filing your application. You want to look on the internet for any clearance research to say, hey, I am seeing this similar mark. I want to make sure that consumers aren't used to seeing these goods and services sold under the same mark. So when you're conducting what we call a clearance search, you would be doing a search in our USPTO database. You go to uspto.gov. It is our trademark search. That's our USPTO database. It's available 24/7. It's like a search engine for our for the federally registered trademarks, as well as federally applied for applications that haven't moved forward to registration just yet. You're also going to want to search on the internet. And this is an option you want to think about when you're searching for that common law usage, right? We've talked about as soon as someone is using a trademark in commerce, they have geographic rights in the state where they're using that particular mark. So you want to search on the internet because we know that trademark registration or filing for a trademark registration is voluntary. You don't have to do that. So there may be entities that are using a mark, have that common law usage, and they don't have a federally registered trademark. So you want to also be searching on the internet for that as well. Now, while we do recommend hiring an attorney to file a trademark application, you're not required to do so. You are able to file an application on your own. We provide you with a ton of free resources in order to do so if you feel confident enough to do so. But when you are, if you choose to hire an attorney, make sure that you are hiring an experienced trademark attorney, not just any attorney, someone who has understanding about trademark law. And they're also going to be doing a search prior to filing your application. They're going to search in that USPTO database as well. They may search state trademark databases. They may search business name registries, as well as foreign trademark databases, as well as looking on the internet. So they're going to be conducting probably a more comprehensive search to ensure that there's no likelihood of confusion. All right, so let's do one more knowledge check before we move on to our other concept as far as the strength of the trademark descriptiveness. So again, our trademark is X-Seed for agricultural seeds. And then the registered trademark is X-Seed for live plants. So think about that one, go through the analysis and think about whether or not you would allow that application for X-Seed for agricultural seeds to move forward to registration. And let's go through our analysis. So are the marks confusingly similar? X-Seed and X-Seed. I pronounce them in the same way. So we're looking at whether they look alike, whether they sound alike, meaning and connotation in that commercial impression. So here they sound alike, even though they don't look alike. And then our agricultural seeds and live plants, are they sold by the same companies under the same marks? Would consumers be used to seeing this? And I'm going to gather just off the top of my head that probably yes, right? You can go into a greenhouse or a greenery or a plant store and you might find agricultural seeds and live plants being sold under the same trademark. All right, so that's likelihood of confusion. Let's talk about our strength of the trademark in connection with that descriptiveness refusal. So here the concept is that you want to avoid trademarks that fail to indicate the source of your goods and services. Remember, we want our trademark to indicate the source of our goods and or services. So if they do not do so, the test here is that we want to see if the trademark merely just describes the goods and services. It doesn't give us any source indication of who is providing these goods and or services. And this is the type of concept that we think about, or the graphic that we're using to make that determination when we're thinking about the strength of the trademark. So you could currently have a trademark, something that you already are using, and you want to think about how to make it stronger, or you're about to build your brand, build your business, and you want to think about how to have a strong, distinctive trademark. So we're looking at this temperature gauge here. On the weak side are generic or descriptive marks. As we're going higher, we're thinking about suggestive or fanciful and arbitrary marks. Those are the strongest types of marks, and we're going to go over each briefly. So with generic terms, these are common everyday names for the goods, indoor services, right? No source indicator here. It's just what you would call that particular good or service. And this is unregistrable. These are very, very weak marks on the bottom of that temperature gauge. Think about milk for a dairy-based beverage. That is what we would call milk, right? It's a dairy-based, something that you drink, dairy-based beverage. So milk for a dairy-based beverage is generic. That is what we would have to actually call those particular goods. So it has no type of distinctive way to, no type of trademark source indicating matter. Descriptive, going a little higher, but these are still very weak marks. These directly describe something about the goods and services. So think about whether or not your trademark is just merely describing what a characteristic or a feature, an ingredient, a quality about those goods, indoor services. These are normally unregistrable on our principal register. But there are some instances where you can show enough evidence to say, even though this is a descriptive mark, I have enough evidence to show that in the marketplace, it has acquired distinctiveness so that consumers would know that this mark has some source identifying matter. Okay, so you would have to show the USPTO a ton of evidence, a lot of evidence to show that this descriptive wording is so distinctive that the consumers would know that you are the source of those goods, indoor services. So more likely than not, it's going to be unregistrable, an unregistrable type of mark. For example, think about creamy whip for whip topping. Okay, so creamy describes something about the quality or characteristic about those whip topping goods, and whip is just the whip topping. So this is just describing something about the goods, not giving us any type of source indicating matter. Let's go a little bit higher on that temperature gauge. We're getting a little bit warmer. This is dead center of suggestive marks. Now, these don't just merely describe something about the goods and their services. They suggest something about the quality of the goods and services. The test that we're using when we're reviewing those applications are whether or not that consumer is going to have to take a mental step, like another step to know something about those goods and their services when you have a suggestive mark. These can be registrable. So think about, for example, copper tone for suntan lotion, copper tone for suntan lotion. Okay, so copper tone, a consumer is not going to think that they're going to turn copper, something of that nature, but they may say this suggests something about maybe the color of the skin may turn, something it's going to do to the skin or something of that nature, but it doesn't directly describe something about those goods, something about suntan lotion. Let's talk about our strongest types of marks, fanciful and arbitrary marks. So fanciful marks are invented words with no meaning in any type of language, something that you've just created, and these are registrable. So think about Xerox for photocopiers. Now I'm going to mention some type of trademarks that are very well known, but they are fanciful marks. They've developed enough brand distinction that we hear them all the time, like Xerox or Kodak for cameras, Kleenex for facial tissue, Pepsi for those carbonated soft drinks. But those are made up words, even though we know them, have heard them. These are just made up or coined type of trademarks. Arbitrary trademarks are actual words, but they don't have association with the goods and or services that they are connected to. These are also strong, very strong marks, and these are registrable. Think about Apple for computers, right? Apple is a type of fruit, has nothing to do with computers, even though we now know it is a very distinctive brand, one of the most well-known trademarks in the world, but Apple has nothing to do with computers. Think about Gap for those retail store services or clothing. Think about BlackBerry for those smartphones or cell phones, etc. Actual words that have nothing to do with those particular goods, indoor services. So now we know about the likelihood of confusion analysis. We know about the strength of a trademark with that descriptiveness analysis, whether the mark is just merely descriptive, Let's do a quick knowledge check to make sure we have an understanding of the strength of the trademark. So which one here would be registrable? Drop a 1 in the chat if you think bicycle for bicycles would be registrable, or drop a 2 in the chat if you think bicycle for playing cards would be registrable. Thinking about, is the mark merely descriptive? Is it strong enough? And I'm just going to open my chat here so I can see. Drop a 1 for bicycles, or bicycles for playing cards. Which one? Or a 2 for bicycle for playing cards. And I'm seeing come in, I'm seeing 2s come in, right? Bicycle for bicycles is generic. That is what we would have to call a bicycle. So that doesn't indicate the source of those particular goods. Now, bicycle for playing cards is arbitrary, right? Bicycle is an actual word, but in connection with playing cards doesn't mean anything. This is an actual registration, bicycle for playing cards. So it doesn't really mean anything. This is a strong mark for those particular goods. All right, I'll pause here if we have any questions about likelihood of confusion or on the strength of the trademark, that descriptiveness to refusal, just to see if I have any questions regarding that. If not, we'll move on to our filing and registration. I'm just going to check the chat really quickly, make sure we don't have any questions. So let's talk about the filing and registration process. Maybe going through this or coming here today, you decided, hey, I'm going to go through with filing a trademark application. I want those federal registration benefits with the USPTO. And so this is a very linear graph of how the registration process goes, how the filing process goes. You're going to file an application with the USPTO. It's going to be examined by a trademark examining attorney with the office. They are not your attorney per se, providing you with legal advice, but they are an attorney that's examining the application. After that examination is going to go through a period of publication to the public, a notice period to the public to say, hey, this trademark is going to be moving forward to registration. If you have any opposition to that, you need to let the USPTO know. There's a 30-day opposition period. If you don't receive any opposition, or if you do receive opposition and it's not upheld, by the trademark examining attorney, you'll move forward to registration. Like I said, this is a very linear graph because there could be instances where you might receive an office action for likelihood of confusion or for descriptiveness or other application requirements, and you would have an opportunity to respond to that office action prior to it going through the entire process. So first, when you file that application, you're going to be doing that electronically in our trademark electronic application system. You only file a trademark application electronically at uspto.gov. There are 2 types of filing options. The first is a TEAS Plus filing option, which is $250 per international class, and then a TEAS Standard option, which is $350 per international class. Now, before we move on, I just want to explain those fees and the differences in those fees, as well as what the wording international class means. So when you're filing an application with the USPTO, you let us know what your trademark is, and then you're letting us know what your goods and services are. These goods and services are identified in classes with the USPTO or international classes with the USPTO in our identification manual. There are 45 international classes, different types of groupings of goods and or services. International classes just refers to the World Intellectual Property Organization, who has come up with these particular headings. It does not mean it identifies any type of international protection, right? We know that when you get that US registration, you're just getting US-based protection for your registration. So $250 per class for the TEAS Plus option means that you're going to be providing us with a little bit more information up front. You're going to make sure you're giving us all the requirements we need for the application. And in regards to your goods and services, you are choosing something that has already been accepted in the trademark identification manual. So it makes it a little bit easier for that trademark examining attorney to review your application because those goods and services are already in the identification manual. Now with TEAS Standard, $350, you're like, why is it more $100 more? You may have goods and services that one, you may just want to write in. You don't want to use something out of the trademark identification manual, Or you have something that has been created that is new, that has not currently been accepted in that identification manual that you have to write into your application. And so that's $350 per international class. Now, when you're filing your application, you're going to be doing that electronically. You're not going to be having to do math in your head or writing it down. Every class that you put in your application is going to add that up for you, and you'll see those fees at the end of the application process. So say, for example, if you're doing T's Plus for shirts, which are in class 25, for clothing, apparel, goods, class 25 for shirts, $250 per class. And then you're also doing handbags, which is in class 18. For leather goods, those type of goods, that's 2 classes, so $500. So that's how your fees accrue. If you're just deciding to do 1 class, you would just be paying that $250. You can have as many goods and/or services that are identified in that particular class. You just pay 1 fee for the class. So for class 25, which is normally clothing and apparel goods, you could have shoes, shirts, dresses, pants, hoodies, hats, jackets, all of those goods in that 1 class, and you just be paying that 1 fee. So what's required in your application? Your application, 1, you're going to give us a clear drawing of your trademark. Doesn't mean that you have to actually draw your trademark. If it's just words or terms that you're using, you're going to be typing that into the application. But if you have design elements, color elements, etc., you're going to give us a file of that particular trademark. So a clear drawing of your trademark. You're going to be telling us what your goods and services are that you're using in connection with that trademark. You're going to let us know the filing basis or the legal reason you have to file this application with the USPTO. And just really quickly, the most common types of filing bases are 1A, use in commerce, and 1B, intent to use. 1A, use in commerce application means, hey, I already have a trademark that I'm using in commerce with the goods and services that I'm putting in this application. I'm able to show evidence of that. And so I'm filing under, I'm currently using it, use in commerce 1A filing basis. 1B, intent to use filing basis is saying, hey, I have a business that I'm starting. I have a trademark, but I'm not currently using it in commerce. Remember, our trademark rights in the US are based upon use. So you're not currently using it, but you know that you will be doing so within 3 to 4 years. So you can go ahead and file that application. That prevents someone from coming behind you and filing a similar, confusingly similar mark for same or related goods and or services. And then you would be paying an additional fee at a later time when you are using your mark in commerce. You have to do that within 3 to 4 years. You pay that additional fee. It changes it over to that 1A filing basis, and then you're able to receive a registration. You're going to provide us with your contact information in the application, as well as with the filing fees associated with your application. Once you file that application, it goes through that examination process with the trademark examining attorney. These are some of the common bases for refusal. You may not receive a refusal in your application, so I don't want to scare you, but these are some of the most common bases for refusal. We talked about that likelihood of confusion refusal. We talked about that merely descriptiveness. Hopefully you've already done your research prior to filing so that you can eliminate even that coming up as a basis for refusal. Some other common types of refusals are that your mark is geographically descriptive of the origin of your goods and services. So not just descriptive of the goods and services, but you're merely just telling us where the goods and services are from. Specimen does not support your listed items. So when you file your application and for your registration, you have to provide us with evidence of use of that trademark in commerce with your goods and or services. This is called a specimen. That evidence is called a specimen. So you might submit a specimen that does not support the use of the listed items that you have in your application. We're going to give you a refusal saying, hey, we need another specimen because this doesn't show that you're using the market connection with the goods and services. Another type of common refusal is that the mark is being used in an ornamental or decorative manner. So say, for instance, you have a trademark and you have the wording emblazoned across the front of a t-shirt for your t-shirt goods, or it is on the front of a hat for your caps. Now, that is just showing us that you're using the mark in a decorative manner. It doesn't really indicate the source of the goods and services. We want to see a hang tag or a label inside of those goods. or maybe the mark on your e-commerce site where you can purchase those particular goods. So once you've gone through that examination process, say even if you have received any type of refusal, you do have the right to respond to that refusal with the USPTO. Say you move forward to registration. The USPTO does not enforce your trademark rights. So after you receive the registration, you're responsible for enforcing those rights, preventing someone from infringing upon your US trademark rights. Now you can use your federal registration to send cease and desist letters, or like we talked about at the beginning, to file a suit in federal court to sue an infringing user. After you receive your trademark registration, you may have that trademark registration in perpetuity as long as you are maintaining your trademark registration with the USPTO by filing post-registration documents. These are required filings that you file with the USPTO. You file them first within the first 5th and 6th years, then between the 9th and 10th years, and every 10 years after that. There are filings and fees that associate with that. But as long as you're doing that, or your business entity is doing that, then you're able to maintain that federal registration. All right, we're at the end. We've covered everything briefly about that federal registration process, and then we're going to talk about a few materials and resources before we get into some questions. Let's do 2 quick knowledge checks. Are you guaranteed registration of your trademark? When you file your application with the USPTO, is it guaranteed that you are going to receive a registration? And I'm seeing the no's coming in. Thank you for your participation. No, right? We know there's no guarantee because every mark is not going to be registrable or legally enforceable. So when you file the application, it's going to be reviewed by an examining attorney who's going to be able to make that determination. Last question here. If your trademark registers, do you have to do anything to keep your registration alive? Do you have to do anything to maintain your registration? Looking in the chat here. Is there anything you have to do to keep your registration alive? And the answer here is yes, right? You must continue to file post-registration documents in order to maintain your trademark registration. Okay, let's quickly go over some of the resources so that we can get any questions that anyone has. And keeping in mind that any resources from the USPTO, most of the resources from the USPTO are free resources. So first, I just want to notify you or alert you to scams, or alerting you to scams. I have some links here regarding scams, regarding filing forms, as well as misleading notices and offers. So when you file an application with the USPTO, it is public record. So others are going to be able to see that. We have to do that, one, so that others may see if there is going to be any infringement on their currently registered trademarks, but also you may be contacted or solicited by others in regards to that trademark application. You might be solicited by legitimate attorneys who want to assist you with the process. But you can also be contacted by those who are providing fraudulent communication or fraudulent correspondence to you via email. So just be aware of those. On these particular links, we try to keep up with certain organizations that are sending out things, as well as usually they're going to be asking you for some money. They may say, hey, we can guarantee registration of your trademark application if you pay us $3,000. Now, you know, just by sitting here that there is no guarantee of registration, that when you file that application that it's going to be reviewed, and there's no guarantee of that. So you already know if someone tells you that, that is more likely than not true, or that they could be fraudulently trying to receive money from you. I'm also going to provide you with our customer service number as well, so that you can verify any communications that you may be receiving if you're unclear or unsure if this is something that is coming from the USPTO. As always, your hub is going to be uspto.gov. We have videos on our website from attorneys in my office, our trademark customer outreach office, that are providing videos about all aspects of the federal registration process, as well as our trademark basics registration toolkit. You can go to that link there or scan the QR code that is currently on the screen. That's going to provide you with more concise information about the process, as well as the links that I'm providing you as well to different phases of the process that you may be in. I also want to alert you to our Trademark Basics Bootcamp. This is our 8-week series that the attorneys in my office provides that guides you through the federal registration process. So you're able to go to that link there. It's also in our basics toolkit through the QR code. That is an agenda over an 8-week period of going through the process of federal registration. The attorneys are live, like myself. I'll be hosting the next session. That'll be starting on October 1st. It's every Tuesday for an hour, hour and a half. I'll be hosting that session. I'll be live. You'll be able to ask questions. If you're deciding, hey, I think I might want to do this process myself, you can go through these videos and get all the information that you need in order to feel confident in order to do so. So if you want to join me starting October 1st, please do go to that link and sign up and register. Also, our IP identifier provides you with information about intellectual property in general. Like you may say, I think I have several types of intellectual property. I don't know which one I have, and I don't know where I need to go in order to receive protection for that intellectual property. The IP identifier will provide you with information with a quiz or questions, not a quiz, questions about your type of intellectual property. And then at the end, we'll be able to tell you where you need to go for the different types of intellectual property you may have. A link to our free services and resources here, uspto.gov/free services, as well as our USPTO virtual assistant that is in beta mode, but it allows you to ask some of our it covers some of our most commonly asked questions and can provide you with further information with any questions that you have on our website. Our Trademark Assistance Center is our main support center for all trademark customers. The telephone number is there. They are available Monday through Friday, 8:30 a.m. to 8 p.m. Eastern time. And then if you email them at that email address, they will respond within 24 to 48 hours. Keeping in mind that they cannot provide you with legal advice. No one at the USPTO can, even if they are attorney, cannot provide you with legal advice. The USPTO, again, does not provide legal advice. We cannot enforce those trademark registration rights, and we cannot recommend specific private attorneys. But if you go to our website, uspto.gov, if you go in our search bar and type in law school certification program, there are law schools all around the country that have intellectual property clinics or IP clinics. These are law students working under their attorney, licensed attorney professor that may be able to take you on as a client for free or reduced fee services to assist you with your trademark application. So say you go through Trademark Basics Bootcamp, or you come to sessions like these and you say, I'm still not confident with filing this application myself. I would like to work with an attorney. For small business owners who meet certain criteria, you may search for a law school near you that may be providing those services. All right, and now we're at the questions portion. I'm just going to stop sharing here and welcome any questions that you may have regarding the presentation. Just stop that here. And I'm happy to put up anything back on the screen if you need to see it as well. So I'm just going to go through the chat here, make sure I didn't miss any questions.
Christina, it looks like we have
Yes.
one from Caleb.
Okay.
Caleb, do you want to come off mute and ask your question?
Yeah, so Christina, thank you. Fantastic presentation.
Oh, thank you.
Excuse me. And thanks to the organization for putting this together. So I've got a bit of a sore throat here. My question has to do with a recent office action that I received. My filing was for the word pre-cover. There's an existing mark for pre-covery, which was filed in Canada and is for an RX, right? And so it's an ingestible RX. Mine has a completely different use. It's for an OTC. And so I don't know this for fact, but I'm interested to get your perspective as an examiner. I suspect the examiner simply looked at the word and said, this could lead to customer confusion. But the customer for the existing mark is a pre-surgery customer. They can only, the purchase that particular product is only available as I mentioned, RX, right? So prescription, hospitals, etc. Mine, words are similar, one letter different, different target is an OTC. And so I wanted to get your opinion with regards to, is this something that I should spend additional monies to pursue? Or alternatively, simply use pre-cover with a TM?
So specific to your application, I can't provide any legal advice, but I just wanted to go a little bit in depth about the likelihood of confusion, office action that you, or the argument that the examining attorney may be making without, because I haven't seen it, so I'm not sure. So as an examining attorney, when we're reviewing that application, like I said, we're going to look at the if the marks are confusingly similar, and probably in the office action, they've explained to you the reason why they believe it's similar, whether it sounds the same, whether it looks alike, whether it has a similar connotation, right, meaning or connotation. And then on the relatedness of goods and or services, they would have had to provide you with some evidence of that. So when I talked about how we look in the marketplace, I didn't know the difference between, whether shirts and golf flags were sold by the same entity. They would be providing you evidence in that office action to show that. So of course, we're only doing internet evidence. So we're going out, we're searching to see, do companies provide this type of pharmaceutical along with these type of pre-surgery, this RX with this type of, are you able to find the OTC as well, under the same type of marks, under the same type of brand name. So they would have provided you with real, what we would call real world evidence, marketplace evidence of that. Now, once you receive an office action, you do have the right to respond to that office action. You can make arguments against the office action. If you agree with them and say, well, I do kind of agree, I don't want to respond. But if you disagree, you can provide arguments between both facets of that analysis. You can argue against the fact that you don't believe that the marks are confusingly similar. Maybe they have a different commercial impression. Maybe they have a different meaning and connotation. Or you could argue against the marketplace evidence as well. And that's something, if you're more in the field, say for instance, if it's a field like, I'm thinking like on the patent side, I'm not an electrical engineer or something like that. And then that's what they're coming in for the trademark. And I can say, this is what I found on the internet. And you may come back with an argument like, in this field, one is so sophisticated and specialized, no, people would not get this confused. If I'm a doctor, I'm not going to get this confused. So you can use whatever arguments. You may choose to work with an attorney to do so, to respond to you on your behalf. You do have 3 months. I don't know when you received it, so I just want to notify you that you do have 3 months from when you received it, which is, right. It seems like a long period of time, but it's not. And then, or you can go ahead and make those arguments yourself. You don't need an attorney to do so, but if you say, I want to work with an attorney, because an attorney may be pulling case law, things like that to argue on your behalf. So that's just a determination you need to make to say, yes, I want to move forward with this. I don't know if they gave the office, the examining attorney gave you an option to maybe change your identification of goods and services to say, you might can change something to make it different so that they can coexist. Remember, I talked about Delta for faucets and Delta for air transportation services. Yep. So sometimes you can have that, especially in a specialized field, but that's something that you can look into to say, well, I disagree, and I want to provide arguments against that. You have the opportunity to do that in that non-final office action. Say they come back and they still refuse it. You have an opportunity again to argue in a final office action as well. If you still disagree, you can appeal to our trial and trademark appeal. I'm going past, but you have the option to continue if you're like, no, I think I want to hold my ground on what my argument is against this.
Yeah. No, I appreciate that. So one of the challenges that we have as entrepreneurs, I indicated earlier that over the last 5 years, I've spent a mint on trademarks maintenance, patent filings, patent maintenance, and trademark, because every time there's an office action, the cash register is ringing, right? Because I don't have the experience. I'm a finance guy. I don't have the experience. I'm not a lawyer. And so we rely on legal expertise, but the whole structure is set up where it's just constant churn, right? And so this session has been extremely helpful. And so before I go back to my legal counsel to say, let's take option A or B, that's why I wanted to get an opinion, because you're sitting on the other side. And so the second part of the question is, if alternatively, I simply add a TM to my brand, do I have any legal risk?
So when you're using it in that common law manner, say you're like, I'm not going to go through the federal registration process, it's not required, it's voluntary, then you might run into the risk of those who have those federal registrations looking out into the because you have rights in whatever state, but then they have those federal rights, which means they should have the rights over all 50 states. You may be, now you can get a state trademark registration. A lot of people opt to do a state trademark registration if they say, I'm not going to be selling outside of, I don't know how you do that in this world, but some people do say, I'm not selling outside of the state or something. I'm not as concerned about it. So you have those common law rights, but you also have to think about those who may have those federal registration rights that could possibly be sending you a cease and desist or something of that nature. And even in that case, you may have those common law rights because common law rights are based upon use prior to. So you can say, I've been using this prior to the time that you were using it, to the time that you received your federal registration. It may be still that you would be needing to hire someone to argue that on your behalf as well.
Yeah. Last thing, I don't want to hijack the
Oh, no problem.
Is my assumption is going to be, if I cannot get the registration through, no one else can either. So if I use TM, I should be safe.
So TM just indicates to the public that this is a trademark. And if you have TM without like that R with a circle, and they can, this is public record. So you can look in the USPTO database. I can go in and click in pre-recovery and see, or pre-cover and see, oh, they don't have a federal registration. They just have the common law rights in the state of Florida, wherever they're using it, wherever their business is based. So someone could still come in and possibly use it. One in another state, they could use it, or they could be using it in the state of Florida for something similar. And that would be therefore be a state issue. So the TM just lets others public know this is a trademark in connection with these goods and services. But then again, you just have the common law rights. Those are just based upon the state where your business, or where you're currently using, or where your business is based.
Got it. Thank you.
So that's why we always suggest that federal registration, because then you have those broader geographic rights. That's like the biggest benefit of having that federal registration.
Okay. Yeah, I'll go back and look at the details of the office action, because I think this is really something that can be challenged simply because of everything I've already articulated, the different use, the different customers and so forth. So, okay.
And you're able, like a lot of, I know it is a legal document you receive, and this is to everyone, all of the attendees. It is a legal document you receive. If you're reading that document, you can call your examining attorney. You can call, they put their number in their email address in that office action. So even prior to applying, if you want to call them and say, hey, I'm just not understanding your legal argument for this. Can you talk me through? I've read it. I have a few questions. You're able to do that. Please don't feel afraid to do that. When you see that examining attorney's name, their telephone numbers. I did that all the time. I would do, people would get an office action and 5 minutes later call me back and I'm like, I know they did not read the office action in 5 minutes. It took me longer than 5 minutes to type it, but they would call and say, I don't understand this at all. And we would literally go through what my arguments were in a way that I probably was a little bit more manageable to them than just reading through all the legalese. So, and even that to say that once you read through and you can say, you could, I've had people do arguments and they basically said, this has a different meaning. Here's the dictionary description of this word. And I'm like, it does have a different meaning. I'm gonna remove the refusal. They didn't use an attorney. They literally said, it doesn't mean the same thing. Here's the dictionary evidence. And then I'm like, oh, I didn't know that this means this in this industry or something like that. And I let it through and they didn't have an attorney. So you can feel confident in making your arguments and don't feel like they need to be the way an attorney would write them or something of that nature. You can do that yourself if you feel confident enough to do that yourself.
That's good to know. Thank you.
Any other questions we have? I did want to just say, as relates to legal services, I see that the law school clinic list has been dropped into the chat. Thank you. I know Black Innovation Leader probably has partners or they know of entities in Florida that could possibly provide you with free or reduced fee. I like to say reduced fee because a lot of times with small businesses, they may be doing some requirements that you have to meet in order to qualify for those, as well as checking out your local American Bar Association for attorneys, International Trademark Association for specifically for trademark attorneys, or if they're providing any pro bono legal services. Your small business development centers, et cetera, could possibly connect you with, for small business owners, could possibly connect you with some legal services that are free or, like I said, reduced fee.
All right. We did not see any other questions in the chat. So
I
we
have one
want
more, if I
to,
may.
you have one real quick, Caleb.
So can you go back to the one slide where you looked at like the custom designs that were patented?
Okay, let me see.
Yeah.
Like the non-traditional.
The non-traditional, yeah.
Okay,
Yeah.
let me
I
go
just want to
back.
understand that a little bit because we're actually designing a custom case, and I want to understand if that could potentially.
Okay. I'm gonna go back and I'm just gonna do it first before I share so nobody is getting dizzy. Okay, here we go. Share.
Okay.
So again, here, yeah, anything that functions as a source indicator may be eligible for registration. And we talked about sound, color, scent, smell, motion, hologram configurations, and shapes. That brick that you see there, it looks just like a brick, but it's actually the Corning Owens mark for the pink color of the insulation that you may see in a house. So that pink color is a registered trademark. So you may have, in certain fields, may have non-traditional types of marks, whether that be colorings for pharmaceuticals, et cetera, things like that.
Okay. Are we getting a copy of these slides?
Yes, I'll be able to provide the copy.
Okay, all right. This is fantastic, fantastic. Just good stuff. Thank you.
All
Any
right.
others?
Well, there were no other questions in the chat. We want to thank the USPTO for collaborating with the Black Innovation Leaders of Florida. Thank you for this 4-part series. As we have mentioned in the previous classes, this is just the start of a year-long collaboration with them. Our next phase of this is the last class in our 4-part series today. During the next phase, we have dropped the information in the chat for you to register to make sure that you are a member. Members will be emailed an opportunity to continue their education with us as the Black Innovation Leaders of Florida. We have a second partnership with a company called Patent Hack, where our members, we will have 10 applications available on a competitive basis for individuals to be able to use their platform to apply for trademark and patent applications. In addition, you also have access through one of our nonprofit partners around the state to get their learning and education center platform and have licenses to get access to that for further education. As mentioned, the USPTO office also has free classes that are registered or are available on their website. And then in November, we will actually start another series with them where we're going to dive a little bit deeper into patents and trademarks for the remainder of 2024 and most of 2025. So make sure that you are following us on LinkedIn. You are a member so that you get our newsletters. You are following our website so that you are aware of all of our upcoming classes, because our goal is to make sure that more minority companies are filing more patent and trademark registrations and having them approved the first time. So with that being said, thank you all for being here and staying a little bit over, and we look forward to seeing you all again. If you are going to be in Orlando on Friday, October 12th and Saturday, October 13th, we have our Orlando Innovation Tour Stop. The USPTO will also have a panel, hopefully along with the Copyright Office, but we're going to have a panel on trademarks and patents, a panel on access to capital, a panel on the SBIR and SPTR grants offered by the federal government, and some other great topics on that Saturday. All right. Well, thank everyone for joining us. Have a great
Thank
afternoon.
you. Bye-bye.
Thank you. Bye.
Bye.